attained a certain level of expertise in understanding civil society and legal rules and their implications. And they have made contributions to such to the world of law and jurisprudence. So those people are called jurists. And when they exercise their prudence in interpreting what law is or in figuring out what law is, that's called jurisprudence. So just it's as basic as that. So let me just start. Like, now this lecture is about, it's not about understanding jurisprudence, it's about understanding what practical applications it has in the contemporary world. Now we live in a democracy. We have this form of government where there are three organs. There's the legislature, there's the, I'm not saying this like hierarchical wise, but I'm saying there's a legislature, there's a judiciary, and there's the executive. And none of these are superior to one another. They are at the same level, and they maintain a level, the checks and balances. Okay, and nobody is superior and nobody is inferior. Even the state is also like executive, and state is a mesh of executive and legislative together. And judiciary is that one organ which interprets the constitution. Now the constitution is the thing which is superior to all these three organs. Constitution is even superior to the state as a whole. So constitution is the basic thing that governs the state, right? So what is constitution? Now you know that constitution in itself is just, it's a book that has been drafted, that has been taken up from variety of constitutions from all over the world. Some of the aspects of it has been taken from the Irish Constitution, some of it has been taken from the US Constitution, some from different sets of constitutions, the Soviet Union constitutions. So they have been compiled in a way by our Constituent Assembly, which not only resonates with us as a nation, and which is very like it compiles everything for what we stand as a country. So this is our constitution. But is the constitution like not changing? It can be changed, right? It can be amended. So it's not permanent. Well, like you must have studied in the features of a constitution, that it's rigid as well as flexible. So the flexibility comes from the thing that it's amenable to amendment. It can be amended. But there's one thing that cannot be amended. That's the basic structure of the constitution. Now, basic structure, what is the basic structure of the constitution? It is those some principles of the constitution that are so like very like imperative for us as a nation, that they cannot be violated or they cannot be compromised. So those basic structure are also laid down by a various landmark judgments. So you must be knowing them. So it's like secularism, it's like democracy, it's like all the fundamental rights, right to life, that those form the part of basic structure. Now this basic structure has come from a legal school called positive legal school, which is also called analytical legal school. Now, analytical legal school was founded by Bentham, but it was like the father of analytical legal school is Austin. Why is that? I'll tell you. Just wait. So we were talking about the basic structure. Now, basic structure. What is the basic structure? It's like the fundamental aspect of our constitution, which governs our country in a form that cannot be abridged. So basically, we can call it a grand norm. You must have heard the notion of grand norm. So this grand norm was first time formulated by a jurist called Kelsen, who hails from the positive school, the analytical school. And he gave out the theory that law is nothing but a grand norm, like it preceded the society. Like it was always there. It was there in the practices, in how the people used to transact with each other, or in their practices, in their actions, much earlier than it was codified. So it's he says that it was always there, and it preceded society. That it was always like the norms were always laid out. They were always somewhere known to the human, and what all they did, they recognized it. And this is the one thing that he said the law is. So, but I think this cannot be what in entirety what law is, right? So He, on the other hand, there were two other jurists in this analytical school. Those were Bentham and and the other one was Austin. Now they had their different notion. Although all these three jurists are from the positive school, are from analytical school, but they have their own notions about law. Bentham said that law should be studied for what it is. Like, it is very scientific. It should be studied through scientific means, scientific methods, and it should be studied for what it is and not what it ought to be. And all those morality and ethical things should not be. Law doesn't concern itself with that. So this is what Bentham said. Now, why Austin is regarded as the father of this analytical and positive school, although he understood law on the lines of what Bentham understood law on, but he had he gave out a very strong theory about law. He said the law is the command, it's a command of the sovereign, which is backed by sanction. Now, this is one of the most strong and powerful, interpretation or recognition of what law was. Although it does restrain law in some way, it does not cover all aspects of law, but still, it recognizes one of the most significant aspects of law. It says that law is a command. Like, it's the sovereign. It's he imposes the law. Law is nothing without the sovereign, and ethical values and moral values are of no use if the subjects which are inferior to the sovereign on which law is imposed, they don't adhere to it, and they'll only adhere to it when there is a penalty, there's a danda. Like, like, if we compare it with our current scenario, what happened in the year 2020 when this pandemic, we didn't feel as threatened by the pandemic in the year 2020 as we feel right now, because now we understood that how deadly it is, and because of these variants and this increased infection rate, now we are very scared of it. But initially in the year 2020, when it just came into India, and we were instructed to remain at home, be in curfew, and observe social distancing, how careless were we? How lousy were we with all this? We were lousy, right? And so all these, so then there were a lot of policemen running on motorcycles with a danda, and they were shooing people inside. So this is what was happening. So it's like normal tendency of human, that until and unless there's a danda, there's a penal, something is penalty or a punishment that is given, they don't follow any laws until they themselves feel to. So right now they're themselves in line, they're kept in line because they're themselves scared. But in the year 2020, they weren't. So this is what Austin said, that law is nothing if it's not backed by sanction, if it's not backed by danda. So that's how you understand law. So this was very a very significant interpretation he gave of law, but it was criticized by Kelsen, who gave the Grundnorm theory. He said that he was, as naturally, he was more drawn to the idea of that people are themselves governed through a Grundnorm, that they've come up and devised these norms that they live by, and it's already there. They are not made to do anything, because that's how he saw it. So now you understand that although these three jurists have come up from the same school of jurisprudence, they are from the positive school, they're from the analytical school, but still they have this certain notions of law that are just very unique and particular to the way they saw law. So when we see all these aspects, see law for what it is, it's a command from the sovereign backed by sanction over its inferior subjects, and then that it's a Grundnorm that society is already living by, then we understand law in a better manner. So this is how jurisprudence works, and this is how you have to recognize it, right? Now, what about the other schools of law? Now, you must have heard about Historical School of Law, and names like Savigny, Henry Maine, Puchta might come into your mind. You must have studied somewhere. And so what Historical School said was, it said it was very close to what Kelsen said in being in positive school, that the society already had certain ways of exchanges, certain rules that they were already practicing. So that was law. So historical school, although it's a different school, but somewhere it just comes close to it. This is what it is, right? Some schools have a variety of similarities also. It's not like that there's different schools and very distinctly different, and it's every school is like very different from the other. It's not obvious, so it's not necessary that way. So historical schools said on the same lines that how Kelson described law to be, that law was already there. It was not codified. It was not, law is something that cannot be created. It exists in the societal consciousness. It exists in the spirit of the society. Now, spirit of the society, Savigny called it Volksgeist. Now I'll pronounce it as Volksgeist, but the spelling is Volksgeist. You must have heard it, you must have seen it in your books. Now he said the law is actually the spirit of the people. Spirit of the people means that the common consciousness of society, that the way their traditions are, their usages, and how society from its primitive stages moved to a very progressive stage. So this is what law is according to historical school. It said that first there used to be customs, usages, traditions, but somewhere it moved to a place where it was in an evolved form. It got codified and it got in the form of judgments, in the form of certain other things. So this is how law progressed, right? So this is what historical school says. But also, I'll tell you another school, that is the sociological school. That sociological school says that law is what society transacts with each other. Everybody and every individual have their own individual needs, right? But not everyone is capable of meeting those needs by themselves. We all need other people. We all need services of other people. And due to these mutual needs, we come together in society and we fulfill each other's requirements, and then there's a societal bond that exists, and that figures out, that renders certain rules and ways of being in a civil society, that lays a platform how civil society is functioning. So that's law, that's sociological school. Now you would think that aren't the historical school jurists and the sociological school jurists are coming to a singular point here? Like historical school is saying it's the common consciousness of people, it stems out of the usages, the practices. Like Hindu law was not always codified. It existed in form of certain rituals and customs that we were following from ages, but it got codified much later. So that is an example of historical school, right? But it's talking about society. It's talking about how people are functioning in a social unit, right? And how, so that is like it's drawing a parallel with the sociological school, right? So historical school and sociological school, we can now really make up our mind that they are talking about some similar aspects, and therefore they come close to what law is like. So this is how these two schools understood law for what it was. Now sociological school gave another very important aspect of law. It talked about specialization of labor that we see in our contemporary world, like in major firms. Like there's a service sector, there is the manufacturing sector, there is this, different sectors are there. And due to the progression of society, like in an infinite manner, it's just the sectors have further, become more and more spread that way. So now we have specialization of labor, that every sector has been given a certain role. Like the manufacturing sector takes care of supplying the products to the public, and there's a demand supply connection between the consumer and the manufacturing sector. So and in that manufacturing sector, if you see like how a manufacturing unit works, there's a labor, there's a capital, there's and they like have assigned roles, and these labors are then supervised by the management. These laborers are supervised by the management. So there's a specialization. The management task has been taken by these managers and the heads of the company, which has opened a manufacturing unit. And then there are these laborers and workers who work and produce that particular product that they are like given the job to produce. So, and this is supplied to the public. Now the public, what its role is, it pays for those products. So there's like this exchange of going on. So you see the mutual dependency here, that without one the other cannot survive. If there's no demand, the supply is of no use. And if they are not made to supply, how are they going to exist? How society would come to a standstill. So this mutual exchange is the essence of what the sociological school talks about. It stresses over the fact that there should be specialization of labor because there are mutual needs. Everybody is not complete. Everybody needs a certain assistance of somebody else in order to meet their needs, in order to exist in a civil society. Now I keep saying civil society, civil society. What do you get by civil society? Civil society is basically a society which has certain rules, which has a way, an ethical way in which it behaves, and it's not basically, it's opposite to anarchy. Anarchy, what do you understand by anarchy? It's called lawlessness. If there is anarchy, if there is no law, if there are no rules, would you see any society functioning or even surviving? Forget about functioning. Forget about realizing the potential of society, like what these jurists want. Their aim is that their aim of understanding law is so that society functions properly, not only survives but functions and also reaches its full potential as a civil society. But without law, without any rules, there can be nothing. Like, let's take the example, very normal daily example, the red lights. Okay, the traffic lights. If for even in the rainy season, you see sometimes that they don't work. So the traffic is like for 3 to 4 hours minimum, there's just this big jam and nobody is able to move anywhere. Nobody is able to, if no wonder if they have their own job, or they have something they have to attend to. Even the people who wanting to go to the hospital for an emergency, how will that happen? Like, those things are not met, right? So this is what happens when even a single minutest rule or single minutest thing doesn't function as it's supposed to be. So this is what anarchy is about. So if one thing is not functional, it has its impact over everything. So this is why there is a need that there is a certain code the public needs to follow. There's a certain way a public needs to move in. So these rules have their own significance. Without these rules, the society will not be able to survive per se. So this is what the civil society and the need for law is like I wanted to explain to you. So we talked about historical school and sociological school and how they try to figure out law. Now, what these jurists are trying to say is that what they're trying to do here is they are trying to get to as close to law as a concept as possible. They want to remove all the complications from the path of understanding law. They want to uncomplicate it, but on the other hand, they end up complicating it by giving such theories and all these. And those theories are not just it; they are criticisms. Like, if not from another school jurist, from the same school jurist, like Kelsen, criticized the jurist of its own school, Austin. He criticized the Austin, notion of law, that law is nothing if not backed by a sanction. It's a command of the sovereign, and the sovereign is superior and the subjects are inferior. So Kelsen criticized it. He didn't agree with it. So he gave his own criticism and then he gave his own theory. So this is what jurists are doing. Like they have done. Like, they came up with their theories, and not only their theories, they criticized some other jurists who theory hailing from some other school of law. So this is what jurisprudence is. Their purpose and their motive is noble. It's actually they want to understand law so that they can suggest any modifications in it. They can introduce reforms in the way things work, and basically all they want is the betterment of the society. So that's why they have come up with these theories. So we were talking about these two schools, historical school and this sociological school. Now there was this another school which was like the first, like, philosophical school and natural school. it also has some lines of similarity with the sociological school. Now, the jurists from the philosophical school were Grotius, they were Hobbes, and so these jurists, what they said was that law is like how a man rationalizes what he perceives. That like these jurists gave the ability to think or rationalize of a human being like a very much importance. He said that the person perceives the outer world and in a manner, and each person develops their own understanding of what the outer world is, and that is like that tells them how to be in a society. But I think it is a very overly optimistic approach, because if everyone is that intellectually like uh, intellectually well off, then I don't think there'll be any need for other society. There'll be any need of penalty or any person keeping in check or any head of the government or a ruler or a basically somebody who's superior, sovereign. So there won't be any need of a sovereign. Everybody is very intellectually aware of what law is. Then I don't think so. This, although the philosophical school tried in its own way that what law is, but it doesn't really come close to what it is actually. But it also talked about one very important aspect. It talked about social contract. Now, what was the social contract? Now, this word social is again there. You see, the sociological school also revolved around some social aspect. Historical school also revolved around some social aspect. But the social world also has its references in this philosophical school. So, philosophical school says that there is a social contract. It's between the state and its subjects. The subjects, which are the people, it says that the people are born free with all the rights in the world. They are free and have all the rights, like right to life, right to freedom, right to property, and all the rights are like possessed by that person. Now, what they do is they surrender some of these rights so that they get the protection to the state, so that they get the protection of the state. So basically, there's a social contract happening. People are surrendering their rights to the state, and the state is taking care of the people, and they are like giving security to the people, security to their right to life and other rights. So this is a state of social contract. Okay. Now, what kind of an example you can see like in our world? Now, you have that article, right to freedom of speech and expression. Okay, and what does it say? It says that everybody has right to move freely, everybody has a right to freely profess and practice their profession, and everybody can assemble whenever they want, wherever they want, if they want to, like in case of any labor unions, they can assemble at any place. They can express themselves the way they want to. So you see that somewhere it is saying that people are free in what way they want to be. Like if you are not given those freedoms, then somewhere your right to life and right to live with dignity gets compromised. So it's also connected to the article 21, right to life. Okay, so this is what is said by this right to freedom. But you also see that in the same right, there are certain reasonable restrictions mentioned. It says that you are free to exercise these rights. There's a freedom of speech and expression, and you can do things, but you cannot bypass certain things. Like what are those things? Like they are the security of the nation, integrity of the nation, public health, public morality. So these things cannot be bypassed. So that is what the social contract is about. Like you are given some rights, but you can't exercise those rights in a way that it has a negative effect over the rights of everybody else. Because it's not like you only have the rights, everybody has got the rights. So the way you exercise your own rights, it has to be done in a way that it doesn't compromise on other people's way of exercising their rights. So who keeps that check? I mean, people can't keep that check, because when people get rights or people get unfettered power over something, the most common tendency is to abuse that. Like we've seen, with great power comes greater corruption. Like we see in our day-to-day news, and we see how the things work in our society. So this is what happens. So until and unless there is a restriction, and who brings that restriction? That is brought from the state and its organs. Like the judiciary keeps in check. A government also has its own officers. Like the police is the hand of the government, the executive. So police also keeps in check that the like not no person is flouting the legal rules, and no person is deviating from what law and order. So they keep that check. So this is what the state does. Now you see that philosophical school, although it was initially talking about something like they like how you internalize the outer world, like how you may see the world from your mind. So that was on some vague lines according to what the practicality of the world. But this very thing, the social contract theory that emanates from the philosophical school, is one of the most important teachings that can be taken from the jurisprudential theories. So this is one of the very important theory from taken out from philosophical school. So that's how philosophical school also becomes a little bit relevant in our day-to-day lives. Now we've talked about all these schools. There happens to be another school called the realist school. Now this realist schools, the moment you hear the word realist, you see that okay, now something practical. You know, realist is like in what your idea can be about it is that it might talk about certain doable things, and doable must talk about certain doable theories which are practical and pragmatic, and not like Hawaii baatein nahi hai. So this is, although realist school also is emanating from mostly America. You'll find jurists like Holmes, Gray, and these jurists are not as talking about society. They're not talking about history. They're not talking about philosophy or the nature of being of humans as a society. It is talking about that law is nothing but what the judges do. So basically, it's saying that law is what the court decides, how the court functions, and what the court directs. So basically, it's stressing on the organ of judiciary. It's stressing there. So you can actually see that right now, all those precedents, they are living law. They are like law in their own regard. So although they are not what in entirety what law is, but they are one of the key aspects of law. So this is what the realist school says. It stresses over the court and what the court decides. So it says that law is nothing without court. So this is what realist school is all about. Now I think I've told you about mostly all the schools. So I know that there are like many aspects. Every school has its different set of theories, and there is much more to study in every school. But I've given you a very broad idea of what each school stands for. Now you might understand that jurisprudence is nothing but these jurists actually perceiving society, what's happening around them, rationalizing it in their own minds. That is like one aspect of the philosophical school, and giving out certain perceptions for them, which is like according to them very important for the society to move in a particular direction, to excel, for reforms to be introduced, for society to become better. So this is the motive of every jurist in a like why they give out these theories, and why the jurisprudence as a subject exists. So I think this is what I wanted to say about the jurisprudence and its implications over the present world. I hope that I have able to get you a little bit of interested in this subject, although you might still resent it for its like humongous data, humongous theories, and all these in this matter. But once you really get it for what it is, like I explained to you, you would respect it more. You would yourself be curious to know how law came into being. And because it's your profession, it's your life. No matter if you're going to go work in a firm or become a practicing lawyer, or work in the judicial services, like there, you'll be representing yourself. And if you're not confident in the field, like what field are you hailing from, what that field is about, and how it came into being, how will you be confident in doing anything like concerning your jobs in this legal field in future? So it's very important for you to just understand what your field is about. And even if you become judicial officers, they are like, if they don't get law, then they won't be able to write judgments. You see the judgments, 1,000-page judgments. So you can be made to you are made to write those judgments. So in future, if you become a judicial officer, it's you like, no wonder like you see these people reading books of jurisprudence. Now I know you're in student life. You're the only purpose that you want have is like getting through these exams and just having fun. But to have certain, please, I'll really suggest you to please always maintain a certain connect with what you're studying, because it's going to help not only in your personality development, but also once you really enter into this field after the college. Right now it's just all about studies, exams, and probably some extracurricular activities, cultural or moods. But once you step out of your college, it's nothing, not even your CV, not even your accomplishments. It is how your personality has changed, what this bank of knowledge you have, and how confident you are with regards to your knowledge, your legal acumen, and how you want to go ahead in life. Your direction is very precise. So all these things matter. So this is what I suggest, said that no matter a subject is appearing boring to you, it's appearing very mundane, it's not piquing any form of interest, but still try to be curious about things, because if you try, make an effort to read like a simple theory of jurisprudence with like good amount of like 20% of interest. The moment you understand it, you attach it with the what's happening in the present scenario, you attach it with what examples you see around yourself, you'll feel very like, whoa, what, why was I ignoring this subject? This is like so relevant, it's so significant. So I would suggest that, and I hope that you really got what I was trying to say. I tried my level best to explain you. So yeah, this is about it. I thank you for giving me this opportunity to come up here and give you this lecture. I'll get back to the moderator.
Antara, your voice is not coming. No sound, please.
Sir, am I audible now?
Yeah, now you are.
Yeah. Thank you so much, sir. Thank you so much, ma'am. It was indeed an astonishing and knowledgeable session, and I'm sure that every student in this session must have gathered some drop from your ocean of knowledge. We are privileged and honored to be a part of such amazing, enlightening, and well-informed session by you, ma'am. Thank you so much. Now, I would request Ms. Prabhasri ma'am, Assistant Professor, Genetic School of Law, to deliver vote of thanks.
Good afternoon. It gives me an immense pleasure to deliver the vote of thanks. And I would like to thank our chief guest, Advocate Sakshi Sharma ma'am, who honored this webinar with her inspirational thought. And I would like to thank our beloved HOD ma'am, Dr. Pallavi Gupta, Dr. N.K. Behel sir, staff members, student, participant, and last and not the least, volunteers for making this webinar as a great success. Once again, thank you all for present to be like who are present here. Thank you. Over to you, Antra.
Thank you so much, ma'am. I would thank all the faculty members, sir, and all the students for being so patient. Now we would like to end this session.